Welcome, everybody. Thank you for joining us with our first legal update in Town Hall. As you can see, we're going to be hearing from John Giardinelli, Cody Bellmeyer, attorneys for Tyler and Birch, as well as a market update from your Vice President of Government Affairs and Mayor of Marietta, Gene Wunderlich. Some protocol before we get started. If you guys down at the bottom, there's participants in the chat. If you want to ask your question directly, you can raise your hand and we'll call upon you. I see there are hands raised right now, but we'll call on you guys a little bit later, unless we'll find out if you're having any trouble. There's also a chat. You can chat your questions. And if it's something that the attorneys can answer for you right away, they will, or they will repeat the question to the panelists, depending on who the question is going to. As we settle down to our new normal, we at SRCAR continue to provide you with exceptional customer service. Just thought I'd let you know in the last 28 days, we've received over 4,400 phone calls from you. We have reached out to 3,400 calls directly to you guys, the members. We're here for you. All of the staff is working from home. We are continuing with our MLS and networking meetings every Tuesday. So if you have a property, go on to SRCAR and post it up there. We're doing continual education, such as this town hall, but we're doing education every day, 30 minutes here, an hour there, information that will help you through these times. Also, we are now selling face masks and we have those booties for your shoes. So if you need those and you need supplies, give us a call, make an appointment with us, and we'll be happy to open the doors. You just must wear a mask. And I'm hoping that soon business will go back to normal and we can all see your beautiful faces. And thank you for joining us. So without any further ado, I'm going to let Mr. Giardinelli speak first, and then Cody, and then Gene.
Well, good morning, everybody. It's nice to be back home, even if it's virtual. What we're going to do, this is was advertised as a town hall, so it's not your typical brown bag. I'm going to go over a bunch of stuff that's going to take me probably maybe 20 minutes. Cody is going to be monitoring the questions along with Connie. The way we've been doing this over the last couple of weeks is Cody will look at the questions. If it's something he can answer quickly and it's not of general interest, he'll respond. If it's a question of general interest, then Connie or Cody will present it to the group and we'll walk through it. So that's kind of the summary. What I'd really like to do, though, Connie, if I can, is just hear from Gino first, because I'm going to be as typical, I'm going to be the longest winded. So I thought, Gino, maybe you could tell us what's going on legislatively and in the market, and then I'll jump in from there, because I don't want to step on your toes, because I know there's some really important legislative stuff going on.
Okay. Yeah, happy to do that, John. Thank you. And I don't know how much you want me to cover this morning. If you folks are going to cover the CARES Act, for example, and the different parts of that, or if you want me to briefly address that, or how you want to do that.
Okay, what we'll probably do is again, I don't know the questions that are out there. We can talk about the new SBA funding. I've actually applied for and been granted the loan for a business that I own in Temecula. So I can walk people through that if there's questions about it. C.A.R. came out yesterday with a walk through kind of a process for the new unemployment rules that I thought was excellently done. I can't improve upon that, frankly. I thought they did a great job. What I'm really interested in hearing about, I've been getting a lot of calls and a lot of questions from brokers around the boards that I represent, including in Temecula, Marietta area, about the new landlord tenant bill that's being proposed, and the red alert that went out last week about that. So I realize I could touch upon it, but I know you know more than I do, so you'd be a better person.
Okay, I'll just do a couple of general overview things then, and then if anybody needs more information, either you guys can give it or what have you. The first thing that I'll start with is if you want the most recent access to everything that's going on at the local, state, and national level, I encourage you to visit srcar.org. They have links on there to C.A.R. and N.A.R. and N.A.R. Website. Realtors.org is just a wealth of information, including complete breakdowns on all the CARES Act and subsequent bills that have come out, providing assistance and support to our members, as well as general members of the community. So you can get that information, which is accurate and timely information, better than, it's not rumors, it's not the Facebook BS, but it's actual honest answers to your questions. As John mentioned yesterday, actually, in California, they released access to the PUA, the Pandemic Unemployment Assistance, through the California Employment Development Department, and that is a first. So another thing that I want to mention to you is, if you've never invested in your realtor party, now might be a good time to kick in $20 or so, because NAR and CAR have been successfully lobbying for funding, for support, for protections. The CARE Act was unique, and it contains some very unique things that have not been seen before, including the pandemic unemployment insurance. And that provides assistance for independent contractors, for sole proprietors, and certainly for realtors. And realtors have never qualified for unemployment insurance before. So you can thank NAR for that. You can also thank them for getting you included as an essential service, so that you can continue, even if it's in a limited way, you can continue providing a service to your clients. So, and John will go into it probably a little bit more, but I also wanted to mention that regarding the pandemic unemployment insurance, C.A.R. did come out with an excellent guideline yesterday. I hope you all got that. But C.A.R. also has a COVID relief hotline, and they've extended the operating hours of that from 8 in the morning till 8 at night. And that will be operating at least through May 1st, again, to answer your questions, to try to guide you through. There's also some webinars available on the C.A.R. website to give you more focused information on applying for the pandemic unemployment insurance, for the EIDL, which is another, the economic injury disaster loan, which it provides, again, more support and assistance for you as an office owner. More realtor relief is on the way. The CARES Act was relief number 3. They just passed essentially 3.5 last week, which added an additional 300 and some, actually over $400 billion to the $2 trillion, which was the CARES Act. And again, because some of the programs were so quickly tapped out, the Paycheck Protection Program, for example, was tapped out. So they added another $310 billion to that. Another $60 billion to the Economic Injury Disaster Loan Program, which a lot of you would qualify for as a small business, provides emergency grants and loans. And of course, another $25 billion for testing and another $75 billion for our hospitals, which, as you may be aware, our hospitals are hurting right now. The CARES Act also provided an eviction moratorium for tenants and homeowners. It put a mortgage forbearance clause in for any government-backed mortgages. If your loan is Fannie, Freddie, FHA, VA, and so forth, you can request up to a 360-day payment forbearance, even without proof of hardship on that portion of it. And they will not be able to apply a ding to your credit. There will be no fees, no interest, no penalties will be assessed for the time that you're on that. Some lenders are still unaware of that, and I've had to walk a couple of them through that because their own websites or their recordings, before you can actually get to an actual person, state 180 degrees against what came out in the CARES Act. They said, no, we don't provide forbearance, and we don't do this and we don't do that. And you go, yeah, yes, you do. If you're a government-backed loan, you are going to do this. And of course, government-backed loans are about 80% of the underwriting in the country. So chances are you're probably in good shape there. The tricky part about forbearance is technically forbearance simply means that you don't have to make that payment for some period of time. However, it's up to the lender, and when you get to the end of that forbearance period, if it's 90 days or 6 months or what have you, they can say, okay, this is the amount of forbearance that we have, and now you owe us that as a balloon payment, which makes absolutely no sense if you look at it, because if you haven't been able to make a payment for 3 months of $2,000 a month, you're not likely to have accumulated $6,000 at the end of that 3 months to give them a balloon payment. And so you have to work with your lender in order to address that. And they will be talking with you throughout the process. The best thing you can do is request a deferment, which would actually take whatever arrearage you have, 3 months, 6 months, 12 months if need be, and apply it on to the end of your mortgage. However, not all of them are going to do that. And some of them may want to come back and say, well, you know, if you can repay us an extra 10% a month, you know, for some period of time, then we'll go ahead and do that. So that's something just to be aware of, that it doesn't necessarily mean just because you have forbearance, you're not out from under your obligation. You're simply delaying that mortgage obligation. A second part of that is what they've been referring to, which is a similar circumstance for renters. And the CARES Act initially provided for that a renter could, that they applied a 120-day moratorium on residential tenant eviction filings. Tenants could apply with 7-day notice that they were not going to be able to make their rental obligation, and that they could defer that for some period of time, again, typically 90 days with an option to extend up to 180 days. That was part of the CARES Act. Subsequent to that, the governor has come out with his own version of that. A number of cities have enacted various rental moratoriums, eviction moratoriums, that you don't have to pay your rent. And at this point, I mean, it's extremely difficult. It's something like, I believe as of a couple days ago, there were currently 3 million homes that have now applied for some sort of forbearance relief under the CARES Act. 22 million workers have filed for unemployment. It's just been astronomical. As of the second week in April, approximately 37% of California renters had not made a rent payment in the month of April. And I don't know if it's gone up or down since then, but a lot of people aren't paying rent. Now, again, if you have a federally backed mortgage on your rental property, you can apply for mortgage forbearance on that property. What they're talking about is yet another bill that has been introduced, and we're at that fun part of the legislative process in Sacramento right now, where people are starting to do what's called a gut and amend, and they will take a bill that has been introduced previously, that has worked its way at least partially through the system, and they're ripping everything out of it that probably didn't make any sense to begin with, but they're totally changing the tenor of the bill. And in this particular case, we're talking about AB 828, which was introduced by Phil Ting. And what it does is it takes the CARES Act eviction moratorium and essentially doubles down on it. And it says, you don't even have to let your landlord know, just essentially quit making your rent payment. You may need to go to court, but the court will take a position on whether your landlord actually will suffer a hardship as a result of that. And again, according to the bill, if you're a small landlord who only owns 1 or 2 properties, the court will probably say, yeah, you're going to suffer a hardship and you can apply for some sort of relief on that. But if you are a multiple rental property owner or a landlord of an apartment, for example, and you have 10 or more properties, the court will say, no, you're not likely to suffer a hardship as a result of 30 or 40% of your clients not making a mortgage payment this month. So The other thing it does is it actually gives you, AB 828 proposes to give you a year, up to a year without making a payment. At the end of that year, you would pay 25% less than your regular mortgage payment for the next year. And at the end of that year, you would start repaying your landlord not only the amount of rent that you owe, but you would kick in an additional 10% a month. So you're looking at landlords being out of pocket for a year, down 25% for another year. And then if your tenant decides to stick around and start paying you back the full amount at the end of the second year, rather than moving out and finding a cheaper place that they don't have to repay the loan, then you may recoup some of your. Now, the good thing about AB 828 is it's getting a significant blowback in the market. As you might imagine, the California Association of Realtors is opposed. The California Apartment Association has put together a very extensive coalition that is working against this. They've approached the author, Phil Ting, about this and said, this is, there are already protections in place for tenants. Your bill is not only a protection for tenants, but it totally hangs landlords out to dry. And we can't afford to have that happen in this current economy. So they are trying to prevail upon him to either modify the bill, amend it in some fashion, or actually just pull it. And we were just on a legislative call with California Association of Realtors at their legislative committee meeting with an update from Sanjay Wagle, who's our new chief lobbyist in Sacramento. And Sanjay is saying that the hope is that when our legislature gets back into session, and we're not sure exactly when that's going to be, it could be the early part of May, it could be who knows, but that a lot of these bills, because there are about 2,500 bills currently pending up in Sacramento, that a lot of the legislators will be pulling their bills, will be pulling them back, rather than try to get everything jammed through in a much foreshortened time frame this legislative session. So they'll be pulling what they consider to be not the most important bills. Now, when you go to a legislator in Sacramento and say, are any of your bills not important? No, oh my God, every bill we write is absolutely critical to life and limb. So it's going to be a weeding out process to try to get to what's actually important and not important. The Senate apparently at this point seems to be a little bit looser on that. They've already indicated that they're going to pull back a number of theirs. The Assembly is kind of sticking to their guns so far, but we'll see how that goes. C.A.R. I believe is asking our authors, people who have authored bills for us this year, and I believe that's about 9 bills. And I believe we asked 7 of the authors to pull back and not pursue the bill this year. It'll be reintroduced next year. There's only a couple of bills that C.A.R. feels are fairly critical to overall housing. One including rebuilding after a fire, flood, something like that, that makes some allowances on that. So we will probably see some reduction in the bills going forward, and hopefully AB 828 will be one of those. And like I say, there's every indication right now that he is kind of rethinking that based on the overwhelming opposition that he's seen coming in against that bill from a number of fairly important elements around the state. The only other concern that they have up there is that rather than actually going through the legislative process to get a bill passed, which can be fairly cumbersome, you have to go through a committee structure. You have to pass a committee, then you have to pass to the floor. You have to pass the floor, then you have to pass to the other house. Goes through the same committee structure and then back to the house, back to the floor. The concern is that legislators are going to short circuit the system and just dump a bunch of this crap into the budget trailer bills. Budget trailer bills are usually they deal strictly with the budget, but they've become a tool in recent years to jam other stuff through. For example, AB 5 last year, the bill that seeks to knock out independent contractors, a lot of this crap gets dumped into a budget trailer bill. The budget trailer bill only needs a 2/3 majority to pass. It doesn't have to go through the normal committee structure. It doesn't have to pass the Appropriations Committee, which is a sticking point for a lot of monetary bills, particularly this year when the state's looking at a fairly significant decline and decrease in the revenue that they'll be pulling in. So the Appropriations Committee would normally be a place where some of these bills go to die. This year, they're concerned that they're going to dump them in these budget trailer bills. And again, those only need a 2/3 majority to pass. And of course, the Democratic supermajority in Sacramento has way more than a 2/3 majority to pass. The other problem with those bills when they come out as a budget trailer is they go into effect immediately. So it's not like you have to wait till the end of the year for them to become law. You don't have to wait for the governor to sign it. Those things become bills. They become law immediately. And so there's a real concern that a lot of this stuff is going to get dumped in there. It will not be subject to debate or interpretation or public input or even committee decisions. It will just fly right through. And so there's a very real concern about that. So unless somebody else has any particular questions, we can wait till the end, and I'll go ahead and turn it over to John, because I can see he's chomping at the bit there to get his clock running.
You have actually a question, comment. You have two.
Okay.
First one, regarding forbearance, I have not seen anyone address after initial period if the lender may force homeowners to requalify for the loan modification, to alter payment amount spread over the loan, or added to the end of the loan.
Right now, most of that has not been specified. Right now, it just states forbearance, and initially the portion of it, including from NAR, was being interpreted to mean deferment, but lenders are not interpreting it that way.
Okay, and the second one is kind of the same.
Talking with a couple of them myself, you have to communicate with them as you're going through the process. As you get close to the end, say you're 3-4 months in and your business can start and you can start making mortgage payments again, they will be in touch with you to determine how this is going to go forward. Now, a deferral actually would require them to modify the mortgage. Would you need to requalify? Probably not, but that's not been specified right now. And I know a lot of people are going to be working on, getting a mortgage modification on this to be able to apply those missed payments onto the end of their mortgage payment. But again, that becomes a mortgage modification. And as we know from what we went through a decade ago, and those of us who've been around even longer, when it says mortgage modification, even though there's not going to be a ding on your credit pursuant to the CARES Act, when it indicates that there's been a modification to your mortgage, there are going to be other lenders who look at that if you go to buy a car or something like that, and they're going to go, yeah, this could have been problematic. Maybe they didn't make their payments, maybe whatever it is. So there is that concern. However, I think most people are pointing to the fact that everybody is going through this right now, and so lenders are not going to be quite that sticky. But again, it's going to come down to some extent because, as you've probably seen, Bank of America, Chase, Wells Fargo have some of their own kind of programs in place, and they vary a little bit. For the most part, if you need mortgage forbearance, you need to call your lender. But there are lenders that are actually reaching out to their clients and going, hey, do you need to skip a payment or two? So it's really kind of across the board right now, and there's no hard and fast rule as to exactly how this is going to sort out. Now, Lawrence Yun, our chief economist for the National Association of Realtors, has indicated that he doesn't see any kind of spike in foreclosures down the road, and we're certainly hoping that's the case. In fact, Lawrence has specified that he believes that while there will be a steep fall off in the number of sales, for example, the market will take a deep decline here over the next 2 or 3 months, that as things open up again, we will see an equally steep increase in business. And, you know, the debate is actually whether it's going to be a V-shaped curve or a U-shaped curve with a little bit more time spent at the bottom. But because this has not been a financially driven depression or recession like we saw back in 2008, 2009, they expect the recovery to be fairly robust. And I certainly hope they're accurate on that. Lenders will also be under pressure to work with folks who have missed payments, because they also don't want to drive another foreclosure crisis. They don't want to bump that number up. Our foreclosures at a national level, you know, under the best of times, you have about a 4% foreclosure rate across the country. We've been running at about 2%, and locally we're between 1.5% and 2% of distressed properties between short sales and foreclosures. So, you know, that part of our market has been negligible, and we're hoping we can continue that. And every indication from Lawrence Young is that exactly what we'll do. So before I get to the next question, you'd asked about a brief market update, and I will tell you that as of yesterday, month over month and month to date, in March, to this point in the month, we had sold 833 homes, and March was not a stellar month, but it was actually a stronger month than we had anticipated. It was actually a pretty decent month. Our first quarter through the end of March was off to a screaming start. The third best start to the year that we've seen in the last 4 years. And before that, you'd have to go back about 8 years to get to a stronger first quarter. So we were off to a screaming start. Sales were up about 8-10% over last year, and prices were actually up. Median prices up about 6 to 7% over first quarter of last year. So we were off to a strong start. This month, month to date, sales are actually off about 40%. So not unanticipated, but there are still sales occurring out there, and 833 sales. We only sold 596 across the region through yesterday, but again, that was to be expected. I mean, we're operating under really adverse circumstances. The other thing that has not been impacted significantly, last month through this portion of the month, Temecula had sales, 8 sales over $1 million. This month it's down to 5. Murrieta had 7, and this month it's down to 6. So even the sales of high-end properties have not been impacted that significantly. Of course, some of those sales are probably escrows that started 2 months ago or 3 months ago. And so some of that holdover is to be expected as people work to close those. And some of the problems, and again, C.A.R. came out with some information a couple days ago regarding the market, and we've had and again, not unanticipated, but a large number of folks who have canceled escrows just because of uncertainty going forward. And lenders have also made it more difficult to qualify because they're going through a job verification process almost hourly. And, you know, certainly you get down to the day before close, you get down to the hour before close, and you want to verify that you're still employed and are going to be able to make that mortgage payment and are not going to close on your home and then immediately request forbearance for the next 6 months or a year. So lenders have tightened up. In some cases, FHA and Fannie and Freddie have increased qualifying rates from, you know, the mid 6s, 640, 650 up to 720. So they're making it a little bit more difficult, again, in the interest of making sure that the mortgages that go forward are good, solid mortgages. The last thing I will touch on is median price. Our median price, again, month to date over last month is actually up 1% over last month. So it's not the 7% that we had the previous month, and we'll see how the month ends up. But again, at the National Association of Realtors, they are not anticipating a big dip in prices, because sales that go forward, you know, even though you have fewer buyers, they're also chasing fewer listed properties because inventories continue to be at a very low level. Locally, we're at about 1.5 to 2 months. Last month at this point, we had 1,518 homes in inventory. This month we have 1,515. So inventory is not high. So even though we only have 600 buyers out there that have closed so far chasing that inventory, the ones that are out there are serious, and they're keeping prices, at least so far, they're keeping prices fairly solid to this point. So again, if somebody else has, you said there's another question in there?
Yeah, somebody asked, thus far saying mortgage companies actually negotiating the balloon forbearance.
Well, we haven't seen it come up yet because I just started this month. So we haven't actually seen any result of that or anybody that's been through that. So we'll see what happens down the road. My suspicion is that most of them will need to do that because again, if you haven't been able to make a payment for 6 months, you're not going to have $18,000, $20,000 sitting there in your pocket to make a balloon payment.
Right.
Unless they want to take the property back, which in most cases they're not going to want to do, they're going to negotiate with you on some kind of a settlement, whether it's paying some reduced amount going forward or doing modification and tacking it on to the end of your mortgage because they simply don't want to take that all back.
And don't forget, Gene, that I know you know this, but what we're seeing and hearing a lot of around the region and around Southern California actually is the bankruptcy courts are probably going to get very, very busy once all this is said and done. And so under Chapter 13, if I've got arrearages and I have an equity buffer and I can make the payments on a pro rata basis plus my current mortgage payment, the courts have what we call cram down provisions that will allow. So if I'm a homeowner and I've fallen behind because of something related to the pandemic, they're going to the courts are going to be, I suspect, very liberal in terms of granting these Chapter 13 private reorganizations. It's true also on the commercial side under Chapter 7. Additionally, of course, if when we get to the landlord-tenant issues, the same is going to be true of tenants. That if landlords aren't willing to work with them, the tenants can go in under a Chapter 13, or frankly, just simply liquidate the debt through a Chapter 7 bankruptcy. So let's not forget that the bankruptcy courts are probably going to get real busy come fall with a lot of these issues that where the creditor, whether it be a landlord or a bank or anybody, frankly, are unwilling to recognize the realities of the marketplace. And I think we're going to see the courts very active in terms of those issues. So
I think you're right, John, and I think we'll also see probably some more guidance coming down from the federal government.
Sure.
And they're already addressing, particularly as applies to the commercial market, which they have not addressed a great deal in the initial CARES Act. But we're going to see that too with landlords. I was talking to Jeff Kurtz the other day down at the Promenade Mall. He's got nobody in business in the mall. What do you do?
Right, exactly.
They can't make rent payments. But again, as the landlord, you have a payment to make, which in some cases can be fairly large. So yeah, I think we'll see more guidance coming down from the federal government and hopefully not from our state legislature because they don't tend to do things.
Right. This is going to be like a domino game, only we don't even know what the dominoes look like yet. Because Cody and I had a conversation this morning. Cody's been our go-to guy on the academic side and been doing a phenomenal job for all of the lawyers in the firm. And one of the things that everybody needs to recognize is these issues are changing on a fairly regular basis, whether it's what I'm going to talk about, which are the more mundane issues of liability and forms and all that, but things are changing every day. And what Cody pointed out to me this morning is he's been going through and trying to sort of clean up and get rid of the old information, because a lot of people are relying on information that was coming out at the beginning of this pandemic. Well, we've been at least a month into it now, and we're starting to see some issues settle in. And so we're starting to see now people are starting to think about those issues that are going to be impacting us all when we start coming out of all this, which we eventually will, simply because of the reality is we can't stay in this forever. There will be no economy to go back to. So I just think that there's a couple of key things that I want to talk about that kind of go into all this. which is basically the common sense approach. I think that the creditors are going to have to deal with that issue and the realities of the marketplace. What I'd like to do, Connie, is maybe go through my stuff, and then we got another hour and a half. I'm not going to take all that long. I know that comes as a shock to everybody who knows me, but what I want to do is kind of go through some stuff to kind of bring things current for a lot of people, and then we'll open it up for questions, and we'll answer questions until it's time for the next Hallmark movie. So
Okay.
Let's do that. So a couple of things real quick. I want to talk about just what I usually do with the brown bags. I tell you what I'm going to put on the table, and then if there's something else, send in your questions, and between the four of us, we'll be able to hopefully answer most of them. I'm going to talk about forms. There's 3 issues I want to cover there. The Coven Forms, and I also want to talk about some forms going to come out in June. I'm going to cover a couple of landlord-tenant issues, but by and large, those have become very specific questions about entry and those things. So we'll talk about that a little bit. I'm going to kind of really briefly go over your new MLS rules that go into effect in a couple of days so that everybody's ready in case you have not looked at the C.A.R. MLS website. Go over some miscellaneous stuff. I sent Connie an article this morning. Be happy to forward it to anybody that wants it on the Code of Ethics, because at the National Association of Realtors level, everybody is pretty concerned with what is going to be the standard of care and how will courts retroactively judge what realtors did during this period of time. And I think the Code of Ethics is a great place to start because it's the basis for California law. Talk about some liability issues. I do want to talk a little bit about the fraud, and I've got the best person in the world to talk about locally, which is Gene, because we're seeing frauds of all kinds come up, whether it's cybersecurity fraud, whether it's Craigslist lease frauds, all the kinds of things that are coming up. The Department of Real Estate issued something that came out today. And then just, answer whatever questions come up. So there's just a lot of stuff. There's no way we're going to cover everything, but we'll cover as much as we can. So let's talk about forms. First of all, good news for those of you that were feeling like your plates were a little fuller than normal, and that's that C.A.R. had anticipated coming up with a brand new residential purchase contract in December, and it's 16 pages instead of 10, and it's much, much different than what you're currently used to. They've decided for lots of reasons that they're going to defer the release of that form until December of 2021. So all of the training and all of the things that you would have had to do before December of this year are being deferred. So don't worry about that form. In June, there is normalcy in some places, and so C.A.R. will typically issue new forms that have nothing to do with this pandemic in June and in December. And in June, there are some forms and some revisions to forms that will be coming out. So let me just touch upon, Cody's going to do an article for the association's newsletter. I'll edit it and we'll get it out there. But one form that they were working on in January before all this got started, but was very timely, is a form called the Property Visit and Open House Advisory. And it's a form that will be used to advise potential buyers of issues that seem to come up a lot in open houses and in visiting property. Things like, hey, there may be recording devices at the property, so be aware that you may be getting audio or visually or both recorded. There are issues with a visitor safety. We had a case recently where a woman went into a house, was told she had to take her shoes off, which is now becoming very common, and the floor was very slippery. She was pretty old, and she slipped and fell down the stairs, and so now there's those kinds of issues. What's going on relative to safety and how to protect yourself? There's issues where there may be animals or pets on the property, and again, just a general advisory to be aware that there could be an animal in the backyard or something like that. An issue that actually came up yesterday for Cody and I, which is bringing children to open houses, while even during regular times, that's probably not a great idea, but today is an even more dangerous idea. So there's a section on that, and then there'll be a section on general risk. Then they're going to be coming up with a form called Square Footage and Lot Size Disclosure. It's a form for a seller to fill out as to what source of information they got in order to approximate the square footage for the house that they're selling. The realtor is not to deal with this issue. It's to be basically an advisory coming from the seller to the buyer. Those are the only two new forms that will come out in June. There are going to be a bunch of revised forms, most of them in the landlord-tenant field. There's a notice of change in terms of tenancy form, and of course they're adding a number of paragraphs dealing with rent control and with eviction laws. Of course, we don't know when the courts will actually open up. In Riverside, we're probably looking at August, but by the time we start getting to civil matters, because criminal matters will be heard first, realistically, you could be looking at even later, perhaps as late as September. So those forms are coming out. There's going to be a notice to quit form. This has nothing to do with unpaid rent. This is notice to quit because, and one issue that's coming up all the time is tenants not allowing access to the property. That is a ground in most situations, at least under current law. Of course, we know that what could happen in Sacramento between now and the end of all this. But right now, if you don't allow a landlord reasonable access to his property, to repair property, to show the property, or for some other legitimate purpose, that is actually grounds for a at-fault eviction. There's a notice of termination of tenancy, which will, of course, reflect what the new law that went into effect 1482 in January. There's going to be a notice to cure. This is a situation where the tenant is engaging in an activity that is in violation of the lease, but is curable, whatever that might be. And so there is a form for it now, but this form will deal primarily with those issues under the Tenant Protection Act that can be cured. Then there's going to be some minor changes to the two representative capacity forms that you use when you're representing or where an entity, a trust or a corporation or an LLC is involved. And then for out here, not so much for our city slicker friends in Orange County and LA, but for out here, there are going to be some changes to the septic inspection and well inspection form that you guys are going to use. And then lastly, some modifications to the seller instruction to exclude listings from the MLS. This is the state form, but it's my recommendation. And I just think that because you're in C.A.R. MLS, because their technology is far more advanced than most other MLSs, that you use their exclusion form. Their exclusion form is still a little bit different and will continue to be a little bit different than the statewide form. And so I would recommend that you continue to take a look at that. Now let's talk about the COVID forms. There are a bunch. I just want to run through them quickly because I don't know what questions you might have, but a couple of tips. Number one, and I get to say this because I'm old, this is not blonde, so I can say what I want now, knowing that I have a right, as my age will reflect, to say what I want to say. But you guys got to read these forms. You know, the bottom line is you're charging me a percentage of the value of my house, or you're charging me through the listing compensation a substantial amount of money to guide me through this process. And you're asking me to sign advisories, you're asking me to sign forms. If you're not reading them, then frankly, are you actually even discharging your legal obligations, your fiduciary duties to me? So number one, read the forms, particularly the COVID forms, because we frankly don't know what the courts are going to do with all this liability or potential liability, which I'll talk about shortly. So let's look at the forms. There's the coronavirus addendum or amendment. This is a form. Obviously, many of you already were, as Gene pointed out, there were already escrows pending. And of course, those escrows are now been impacted significantly by this virus. And so it is an amendment to the current contract that will allow you to extend the time for removal of contingencies because of all the issues coming up there. extend time for closing of escrow because of all the issues there, and of course allow for a mutual cancellation either of the entire transaction with a return of the deposit, or allow you to simply agree to cancel the transaction without going through without an agreement regarding the deposit. But I will say this, the issue of returning the deposit where there has been a showable by the buyer impossibility of performance. In other words, I couldn't perform. I lost my job. I got my hours cut down. I was furloughed. I was laid off. I had to stay home because I had to take care of a child because the schools were closed. I believe that the courts are going to be very liberal in interpreting that in terms of getting deposits back to buyers. I could be wrong. I don't have a crystal ball, but I believe that the courts are, particularly at the small claims level where the deposit is less than $10,000, probably going to be very liberal in returning deposits to buyers who have acted in good faith. Obviously, the form can be used as an addendum to the contract, which means in addition to your offer, where you attach it to your current RPA and you pass it along with some extensions of time. And again, you need to think through what you're going to be doing here because it's not business as usual. There's a form called the Notice of Unforeseen Circumstances, and that's all that it is. It's a list of those things that the C.A.R. attorneys could think about. It's been revised recently. I believe last week the revisions went live on the Zippy program. And so it's just a real good form to kind of just sort of advise people, look, none of us thought about this. I know that Cody and I, we're rethinking a lot of issues that we thought we knew. Gene has been pointing out all kinds of things that have been changing and that no one ever anticipated. And so everybody has to be realistic about the fact that there are many unforeseen circumstances. There's a form for your listing. It's the RLA-CAA form, the listing agreement and coronavirus addendum and or amendment. This is a document that can be used to sit down with your sellers, hopefully virtually, but to sit down with your sellers and go through your marketing strategies, the showings, and let them tell you what they want to do. Again, remember, it's their house. Some people are going to be very reluctant to allow people to come in. Some people are going to be willing to allow people to come in, but you need to kind of go over what the circumstances for that would be. And this is a great form, even if you don't attach it to your current listing or as part of your new presentations, it's also a great form for you to have as a checklist so that you can go over the different issues that could come up and try and anticipate what the sellers are going to instruct you in these difficult times. So those are the transaction-related forms, except for one more, which I think is the most important form, and that's the PEAD. It is the Coronavirus Entry Advisory and Declaration. It was revised last week to put more burden on the seller. It's basically an advisory to the seller. Hopefully you've already discussed with the seller under what circumstances people will be allowed to come into their property. And then this form would then be used by all persons, whether they be prospective purchasers, other agents, or could even be used by property inspectors and the like. A couple of things about that form. Again, it's an assumption of the risk form. It's an advisory that basically says to a seller, I'm coming into your property. I am declaring I do not have any issues relating to the virus. And again, a very, very important form. A couple of suggestions on that we've been pretty happy to see implemented. Number one is if you're going to require the form of any potential buyers, put that in your remarks section so that everyone is aware, because all of the realtors have access to the Zippy program, and if they're aware you're going to require the PEAD before any buyers enter the property, let everybody know that so there's no surprises. Number two, if it's a non-realtor, for example, I had a conversation with the president of CREIA, the Home Inspector Certification Group, and a lot of the inspectors are not aware of the form or haven't been aware of the form, and they show up and are being asked to sign this very wordy document. They're reluctant to do so. So send it to them ahead of time so that everything is worked out ahead of time, and people are already made aware, hey, we're going to require you to sign this declaration before you come in, and then have everything signed. I believe that Article 3 of the Code of Ethics, which is the duty to cooperate, is without question as important as it has ever been, because again, now is not the time to play games. I just saw a question pop up: am I allowed to ask the appraisers and inspectors to sign the form? The answer is yes, but keeping in mind that they don't have access necessarily to your ZIP program. So if you simply reference that we're going to require the PEAD to be signed, but they don't have the form. So if you're going to require that, since all showings, all entrances should be done only by appointment, then as part of the appointment creating process, send them the form, tell them they need to fill it out and get it back to you, or at least bring it, but you may not be there to take it, so it'd be better if they could get it back to you. Now, there's a couple of landlord-tenant forms that I think are very good as well. One is the notice to tenant of the ability to pay rent. Gene correctly pointed out that you can't just stop, well, you could, because there's no place to go right now for a remedy, because the courts are closed, but the reality is you can't just stop paying rent because you got lucky. You know, I may be working full-time, I may be working at the same salary, I may have childcare, I don't have childcare issues, so I really am not necessarily financially, at least, impacted by this virus. That doesn't necessarily get you off the hook in some situations. The bottom line is that you should be able, as a tenant, to provide a proof to the landlord that you are unable to pay. And of course, that becomes a case-by-case issue. The next form, which I think is critically important, is the Coronavirus Rent Payment Delay Agreement, which is the RPD form. And this is the form where you can work out in advance the agreements that you might have with a tenant. I've talked to a lot of great property managers, including some of the people that make up your property management committee, excellent property managers who have thought through a lot of this, probably at a much higher level than I can, and they're working deals out in advance. If you're a big property management company, obviously that's a little more difficult because you've got lots of people you've got to talk to, but if you're representing or working with a buyer, with a landlord that maybe has 2 or 3 rentals, tell them, talk to their tenant in advance. If the tenant really does have financial impacts that they've suffered, then work with them. You can offer them discounts, you can defer the rent, you can do whatever you need to do, keeping in mind you're not going to evict them, so you might as well be reasonable with them. A couple of other landlord-tenant forms. Again, there's the Coronal Lease Addendum. Here's the issue, is that there are a lot of properties where the tenant was planning on taking occupancy, but cannot take occupancy now because of various issues relating to the coronavirus. Maybe the current occupant couldn't move out on time because of issues, or maybe the property couldn't be available for whatever reason. If that's your situation, pretty much got 2 choices right now: cancel the agreement or allow a new start date, and that form will provide you with the ability to be able to do that. Then there's also a notice of unforeseen circumstances for rentals. That's the NUCC-LR. And then there is a advisory declaration, the PEAD form, and that's the PAD-LR. And so those are some great forms. C.A.R, I got to tell you, and this is not, nobody's asked me to say this, so I'm just going to say it. If you've ever wondered why you're a realtor and why you pay your dues to the association, NAR and C.A.R., I believe this pandemic has given you more than adequate answers to those questions. Those organizations, your association, C.A.R. and NAR, have done a bang-up job. I exchanged correspondence late last evening with Katie Johnson, who's the attorney for NAR. And I as part of that, I complimented her on what an incredible job NAR is doing, particularly at the national level and in lobbying for you. but the CAR attorneys are just phenomenal right now. And so I would strongly suggest, as part of your daily habit, that you visit the Southwest website, see what they've put up, look at those links, and stay on top of stuff. It's very, very important that you keep on top of stuff. So that's pretty much it for the forms. Again, I can talk more about them, but I want to get into a couple of other issues and then see if we have any questions for the people that have joined us. I know we're going to be recording this, but again, the people that are going to watch later can't answer questions, so keep that in mind. So those are the forms. As far as the MLS is concerned, be aware that the National Association of Realtors has not agreed to delay the implementation of what is being called the Clear Cooperation rules. The Clear Cooperation basically came about because at a national level, NAR saw what we've seen here in California for a long time, which is the misuse of both pocket listings and of coming soon signs. And so what they've done is they've instructed all MLSs that are owned or operated in any way by associations of realtors to implement rules, and those rules will go into effect this Friday. And Zoran told us that who's the attorney for C.A.R. MLS, that while they will go into effect on Friday, May 1st, because that is what they've been instructed to do, they will not start really pushing things until May 4th, Monday, because they'll be closed over the weekend. If you're implementing or loading a active listing, don't worry about it. Nothing's really being changed. But if you're going to utilize some type of a hold, if it's a coming soon, there will be a coming soon status. The coming soon status will require that you do everything you would normally do within 1 business day of commencing any form of marketing, and that has been broadly defined, so it's pretty much everything you would do. And if you're going to do that, you're going to be able to put it in the coming soon with your photos, all that kind of good stuff, offers of compensation, but you're not going to be able to do showings because it's off market. You'll be able to keep it in the coming soon for 21 days, no ups, no extras. This is not coming eventually, this is coming soon. And so you're not going to be playing games with that. And so if you want to do a pure hold, then there's going to be a register format. So take a look at what C.A.R. MLS has been putting. Connie's put all kinds of links, and I know there have been all sorts of people taking a look at the stuff C.A.R. has produced, the videos and so forth. But keep in mind that one reason you want to do this is because of fines. The fine after a warning will be a minimum of $500 up to a maximum of $2,500 based upon your list price. So if your list price so it's 1% of the list price up to a maximum of $2,500. And that's for each violation. Now, if you do this on a regular basis, I suspect we don't have too many of those kinds of people listening in today, but if you're one of those game players, this is not the time for you to play those games, because if it ends up coming to the board because you're consistently violating this rule from the MLS, grievance is probably going to add some articles to the MLS violation. It could be Article 1, because you're not cooperating, you're discharging your fiduciary duty improperly. Could be 2, because you're misleading people about the true reality of your coming soon. It could be 3, because you're clearly not cooperating with other realtors. Could be 12, because your advertising is false. And of course, the board can make the fine up to $15,000. So hopefully that won't happen. Hopefully we won't see anybody doing that. As far as the Code of Ethics is concerned, I would urge you to take a look at them. I've written an article. I'd be happy to send it to anybody that wants it. Connie's probably going to post it on the association's, I don't know how Connie's going to do it, so I'm not going to tell her what to do, but we wrote it, we gave it to her this morning. And we didn't cover all the code, but we covered Article 1 because Article 1 is critical at this stage. People are looking to you for guidance, and it's critical that you understand that you have an obligation to put your client's interests first. Normally that means financial or some other issue, but today it could mean, frankly, their safety. So I put down a list of things for you to think about as you go through Article 1. Article 2 is the duty to basically not lie, not exaggerate. And so one issue I'm going to talk about in a second, because it came up at the national level this last week. I'm on an attorney discussion group, and it came up this week, which is, what do you say if you're aware that somebody has had the virus in a house that you're selling? So I'll touch on that in a second. Article 3, again, is your duty to cooperate. Now is not the time to play games with other realtors. If you're one of those people that think that you can maneuver the situation to double in the transaction, that you're someone that can play games with commissions, I believe you are in for a very, very difficult time on a go-forward basis. So now's not the time. Article 9, make sure everything is in writing, particularly since everything's being done electronically now. Very, very critical that you document conversations and that kind of thing. Article 10, be very careful about that while you're screening people, while you're allowing people to come in, not allowing people to come in, that you do not do it based upon nationality or color or religion. It's got to be done across the board. So fair housing issues are still very important, particularly we've seen some discrimination issues, particularly against certain nationalities. And so you need to be very, very cautious about that. And then Article 12 and Article 16. Article 12 is your advertising article. So that's covered. Let's talk about just something practical, and then we'll open it up for whatever questions you guys might have. See, Cody's been answering a bunch of questions, and so is probably Gene. So I'm not going to worry about the questions unless Cody thinks that that's something of interest. So I keep hearing, and Cody is, we're asked on almost a daily basis, what's my liability if fill in the blank? So let's talk about that for just a second, because frankly, we're not sure of what your liability is going to be. So we're trying to make some good, educated, solid guesses, because we don't want you to be the test case in one of these issues. So what does liability really mean? Well, from a lawyer's perspective, it means that you had an obligation, a legal duty to do something or to not do something, and that you fell below the standard of care, whatever that might be, in discharging that responsibility, either by not doing it at all or by doing it incorrectly, or worse, by lying about it. And then lastly, that the plaintiff can prove that what you failed to do correctly, or what you concealed, or what you did caused monetary damage. Now keep in mind, as to that last issue, monetary damage means what? Money. Now, if it has to do with the COVID situation, keep in mind, we're not talking about a house. We're talking about a personal injury. And so Cody and I have had lots of conversations, and I've done a ton of research and talked to other lawyers besides my own law firm. And I'm of the belief that there's a good argument that these are not going to be covered by your standard E&O. Why? Because a personal injury, as you know, is not covered under your most E&O coverages. So be very careful about that. So what are we talking about standard of care? A couple of things. First of all, I'm of the belief that because the association, NAR and C.A.R. are doing such a great job of keeping you guys up to date, forms, things of that nature, that the standard of care is in a large part being set by the associations themselves, and they're doing the best that they can to try and get you guys as much information, but of course they can't make you read that stuff. So one issue that came up this last week, and it actually came up yesterday in a town hall that Cody and I shared, is the issue of so-called stigma damages. What happens if you're aware that someone in the house that's being sold and or rented actually had the virus or was hospitalized. The question actually came up, should I not disclose it because it could cause a reduction in the purchase price? And I believe universally that the answer is no. If you're aware of something, you disclose it. The good news is that the forms that I went over just a few minutes ago simply provide that the seller or whoever it might be will disclose, I have had the virus, I have been hospitalized. And that's it. You're not doctors, you're not caregivers. You don't have the ability, frankly, to interpret what all that means. That's not something any of us at the layperson level are qualified to analyze. And so you simply disclose the existence. And well, what if it affects value? Well, everything you disclose might affect value. If you disclose the fact that there's a crack, that there's been a problem with the septic, whatever things you've historically had to disclose, we're going to a certain extent, affect value. But again, this is a virus. This is probably in some ways, in terms of a long-term, no more and certainly maybe even less of a problem than mold, right? I mean, in mold, the property can be bleached, it can be cleaned, it can be retrofitted, as long as it doesn't get past a certain point. Well, this is a virus that's going to die from what I understand. And so as long as the house has been disinfected, the fact that somebody had a problem doesn't necessarily mean that the house itself has been stigmatized. So be careful about that and be careful about other ways of disclosing. Be aware that there could be privacy issues. So be careful about using names. Be careful about confidential information. But having said that, if you're aware that someone has been impacted in some way by the virus itself, then I believe you're going to have a duty to disclose that, or certainly if the seller's acting appropriately, and you should be talking to your seller about making sure that they make those disclosures, I think that's really all you need to do. And then on the buyer's side, you can investigate whatever you want. But again, the house isn't sick, it's the person inside the house that got sick, and there are ways of fixing that problem. We've been getting a lot of questions about entry. And so just keep in mind some basic rules. Entry should be limited. Entry should be virtual wherever possible. If it's not feasible, then entry needs to be carefully orchestrated by you. It should always be by appointment. Cody and I sat in on a call last week, and we made all these comments about making appointments. 5 minutes later, they were doing, it was a caravan type meeting. We had about 200 brokers involved, and this guy comes on and says, hey, if you want to see this house, I can be over there in 10 minutes, come on over. And we were laughing, we were emailing each other, laughing about, really? You know, you're gonna do that? So the bottom line is make sure that you have appointments wherever you have to do a physical entry. Limit the number of people. I negotiated an ordinance last week with the city attorney in Long Beach. And LA and Long Beach have very specific rules. Gene, I don't believe the rules are quite as restrictive out here, but basically you shouldn't go in with more than 2 people. So if you're going in with 1 buyer, that's fine. If you're going in, if 2 buyers show up or the whole family shows up, let 2 go in at a time, and frankly, only people that are necessary to the transaction. The appointment should be set up in a way that takes care of all the PEAD issues and all these other kinds of things. And again, the cooperative cooperation between the 2 agents. In Long Beach, their rule is pretty strict. You can't go in even if it's a husband and not a husband and wife, but 2 people that are going to buy a house together, unless you've been residing together prior to the pandemic, or during the pandemic, I should say. In other words, that you've been quarantined together. So if I'm going to be getting married and I want to go see a house that my future spouse and I want to buy, I cannot go in with her unless I've been living with her. And that's the Long Beach ordinance. That's not true out here, but just understand that you've been declared an essential service. That doesn't mean business as usual. What the government has given, the government potentially can take it away. And so you don't want to screw it up for everybody else. So far, so good. So far, so good. You guys have been doing a pretty good job, frankly. And so just be aware you got to limit the numbers. Use the PAD. Use your MLS. That's a great tool. And only allow, if it's a buyer that's going in, only allow qualified buyers. The recommendations that have been coming down from NAR and C.A.R. I think are good recommendations, which is pre-approved people. I believe we're going to start seeing a lot of what's going on during the pandemic become the norm post-pandemic. And one of those things is, unless it's an open house, which you can't do right now, except virtually, that you limit the type of people that are going to come in. Either they've made a contingent offer, so you know they're real, or they've pre-qualified, but don't just allow looky-loos to go in, and then only necessary people. Staging is probably prohibited because it's not an essential service. If you're going to do staging, follow all the rules that that Gene's put everything, Connie's put everything up on the association's website. Read those rules. Make sure you comply. If it's a listing, hopefully you've sat down with your seller, determine what kind of issues you're talking about. Inspections, again, work the Avid things out ahead of time. And if it has to do with appraisers or something like that, again, they need to follow the rules. As far as signatures, most of you have been using and will continue to use the electronic signature format. Perfectly okay unless something has to be notarized. California does not allow yet for remote notarization, so you're going to have to work something out with the notary. There are notaries that will do it for, of course, a little bit of an increase in price. Most of the landlord-tenant questions have been coming up in terms of evictions. Bottom line, you're not going to do it right now. All evictions have been stayed probably till August, if not longer. So as far as getting tenants out, we've had some horrific, I mean, obviously if somebody's not paying the rent, that's bad, but we've had some really horrific tenants doing some really bad things, and hopefully that won't happen to you. But if it does, talk to your lawyer and make sure you understand what your rights are. A lot of these things have also come up in terms of a tenant refusing entrance onto the property, so be aware of those rights, and if there's specific questions, we'll try and answer them. And then always remember, as I mentioned before, that the bankruptcy courts are going to get real busy, so financially be prepared for that. And then again, be aware of the fraud. We're all working remotely now, so there's lots of opportunity for the cyber bad guys to hack in. Zoom is not the most secure situation, so there's some issues there if you're going to be using Zoom a lot. But Gene, I know that fraud has been pretty prevalent. I know in Long Beach they've had some issues with Craigslist. I know in some areas SBA frauds and people getting emails from the IRS. The IRS does not use email, and they will not call you. So don't fall for that trap. And of course, ADA issues are coming up a lot now as well. So it's a grand opportunity for you guys to rethink the way you do business, even on a go-forward basis. So with that, I will open it up for questions for Gene, for Cody. Well, Cody, do you have anything extra that you'd like to add that's been popping up in your world?
No, I think right now I'm seeing a ton of questions come up. I think based on our time, it would be wise to just tackle those, as a lot of them are duplicative, and we can probably address them in bulk.
Okay.
If that's all right with you.
Okay, whatever you guys want to do. I'm here. I got no place to go. So Gene, looks like you've got a pretty good backdrop there, but I suspect you're home as well. So
No, I'm standing out in the middle of the street.
Are you? I thought I heard cars go by.
Social distancing.
Yeah. Yeah. No, it's
just want to make one point if I could. John brought up the fraud issue, and yes, we are seeing an increase in fraud. Anytime you get an opportunity like this, there will be people ready to take advantage of it. One thing to be extremely careful of is one of the things that's cropped up is just like 10 years ago, the companies that will help you do a short sale and for a fee, or make your mortgage payment to them, and they will make everything work for you. Don't do it. These are third-party companies. They've already arrested a couple folks. But you know, they're promising that they can negotiate this for you, get you a mortgage deferment, that you don't have to make any payments, you know, for a year, whatever, and they will help you, or they will help you apply for pandemic unemployment insurance, or they will help you get a small business loan for a small fee up front. And absolutely, it's fraudulent stuff. We are also seeing another increase in, surprisingly, because we've kind of had a handle on this, but as John pointed out, the Craigslist scam, you know, somebody will take one of your properties that you have listed and put it on Craigslist as a rental property and solicit first and last month's payment for people. And, you know, it goes back to the old saw, you know, hey, I just, you know, I was just deployed overseas and my property is going to be vacant for a year or 2 years, and then I'm going to have to come back. And so I'll rent it out at below market rate just to get somebody in there quickly. And if you send me first and last months, then I will send you the keys. And, you know, they can talk 2, 3, 5 people into sending them first and last month's payment. And then the keys, of course, never show up. So just be aware that that's going on out there. Double check your own property listings, because you may, especially if you have a vacant home listed, it may well show up on Craigslist, and you may well end up with a squatter in there that you have to go through. And again, right now, given the fact that there's a moratorium on evictions, we don't know how that would turn out. If you had a squatter move into your house that you would normally have to go through an eviction process on, good luck with that, because we just don't know how that's gonna work right now, because there is a across the board moratorium on evictions. So just be very careful out there, because yeah, anytime you get a turbulent market, it opens the door for people who are thinking 1 or 2 steps ahead of the curve.
Connie helped me put a survey out, not a survey, but, you know, kind of get some information from the property management people that, you know, we're not seeing a really large spike in unpaid rent, at least from the April rent. You guys have been doing pretty good in terms of that. The tenants have been, for the most part, paying. It'll be interesting to see what happens on Friday and through next week as the March or as the May payments come in. But again, I guess the best advice is Gene's part of I think you're still part of that fraud group at the DA's office. That's still going. If something doesn't smell right, you got to let Gene know. This board actually put away the biggest scam I think that California ever had, the Stonewood scam a couple of years ago, $180 million scam. And Gene and I and Connie worked on that, and the guy got 80 years of free vacation at Club Fed. And so if you smell something not well, you need to let somebody at the association know, because again, if it's happening to you or your client, there's a real good chance it's become a spread of another kind of virus. And so
John,
you need to be really, really careful about that. So
John,
that's basically that. Yeah. Go ahead.
I have people asking about unemployment insurance. Do you have any information on that for the realtors?
The best information I can give everybody is to go to CAR.org. You probably have the link up already. And they produced yesterday literally a walkthrough of how you do it. It's the first time I'm aware of that independent contractors can get unemployment. So kudos to you guys for being able to get that taken care of at the national level. So go to CAR and just walk through it. If there's a specific question or concern, send an email over. We'll see what we can do to answer the specific question. But the best overall advice I can give you, I actually sent, my daughter's an independent contractor. She's not a realtor, but she's an independent contractor. I actually sent her that article because they did a really, really fine job. So
I have one
also,
person who's already,
if I might, Connie,
yeah.
You should have gotten a link to that in your own email today. C.A.R. sent it out, I believe, to every realtor. So double check your email. I also posted a link to it on the SRCAR Facebook page this morning.
Right. The
So
problem
it
the
is, like
person
John
is
said,
having,
it's an excellent walkthrough that people, all they have to do is pull down the form and it will walk you right through it. This
Right.
became available yesterday in California because the EDD, initially California was a state that did not sign on to this, to provide this. And then ultimately the pressure built and built. And so they said, okay, we'll sign up, we'll provide this, but we need to put a whole system in place for people to sign up because we're not set up to handle this, which is why it's been available nationally for about 3 weeks. It just became available in California yesterday.
And the system crashed to boot.
Right.
So,
yeah.
but yeah, Connie, I can't, all I can say is, you know, we could spend an hour going through the process, but almost, I can't imagine there'll be a lot of questions after someone who's thinking about making the application goes through that C.A.R. document. Any other questions? Cody?
Yeah, there's quite a few in here if I can start diving into those. I think one general one, which we're getting a lot of, is the PEAD. I've seen numerous ones about visitors, vacancies, inspectors, and the like. And so I'm just going to take a stab at broadly addressing and expanding on some of those. And then John, if you want to jump in.
Perfect.
What I would say first is, and this will be my soapbox moment for the day, a lot of these do tend to reflect, just based on experience I'm seeing elsewhere as well, that the default is not virtual showings. And I just want to reiterate, the default should be virtual showings. That's all I will say about that. If for some reason you are forced to go in and actually have an individual enter the property, have a PEAD signed. That should go for inspectors, termite inspectors, anyone who's going to enter the property. If they're refusing, what I would say first is to, again, that by default rule, don't let them in. Speak with the seller, talk through it with the seller. If the seller is adamant that they should be let in, make sure it's in writing and disclosed that they did not sign it, and proceed with the inspection. That would be my advice on that. Overall, the best practice is to get the PEAD signed, though. I've seen a few similar to what we discussed earlier come up about children. Ultimately, it's not a great idea to be letting children in these houses right now. If you can avoid it, do everything in your power to avoid it. If there's been a history or where you know kids involved, try to breach the topic beforehand. Ultimately, though, if they are there, if you cannot leave them in the car, please do not leave kids in the car or encourage people to leave kids in the car. It's hot, especially for toddlers. Don't do it. But if for some reason they are there and they're going in with the child, put them on the PEAD for the parent and have the parent sign it as their legal guardian. It becomes a whole different problem if they aren't a legal guardian, and at that point, you probably really need to not let them in. Anyone, quite frankly.
And we just got a question that should we be sending these forms to the buyer's agent, because sometimes it's the buyer who's arranging for the inspection or the termite or whoever. Yeah, yes. Again, I think Cody hit it on the head that the default is virtual. Well, obviously you can't do that all the time for certain inspections and those kinds of things. If that's the case, then you guys are professionals. Cooperate with the other agent. Let them know, hey, my seller has instructed you will not be let in if you do not execute this form. Obviously, it's a red flag if I'm refusing. Why would you refuse to sign it, right? Why would you do that? But if you're refusing to sign it, or if the inspector says, you know what, I've been told by the way, CREIA did not tell their inspectors to not sign that form. That is, I heard that rumor. That is not true. It's an inspector by inspector, inspection by inspection decision. So if they get it in advance, they can read it over. It simply says, I'm representing, I don't have it, right? So, or I don't know of any conditions or whatever it might be, but there's no real boxes to check off. It's simply an advisory that I'm not aware that I have the illness. And again, it's up to the seller to make the decision. And if Cody's right, if the seller's saying, well, I really got to get this house sold, let them in without the form, then you document that that's against your recommendation and that there was their decision. Protect yourself, because the C.A.R. does provide the form, because they'll forget down the road they told you it was okay. So, okay, go ahead, Cody. I'm sorry, I didn't mean to interrupt, but
No, that was spot on. And I think I'm seeing some other questions. Ultimately, there's no form that says we didn't sign a PAD.
Right.
If they're not going to sign a PAD, they're not going to, but you really need to make sure that's documented, and that needs to be an absolute last case scenario with the seller's express written authorization. I mean, it's not something you can just flippantly let them in without a meaningful conversation beforehand.
Right. There's a lot of talk, and I know Gino's on top of all this, but there's a lot of talk right now about opening things back up. You know, people are going to the beach, people are back out on the road again, but the governor and the federal government have not indicated that this is over. And while all of us, I can't think of a person I know, unless you're really like being at home, that can't wait to get back to some sense of normalcy, whatever that might look like. But for right now, this form is a critical. I think this, and is my personal opinion, I think of all the forms they've come out with, all of which are great, I think this is the most important to have in your phone as a risk management tool. Go ahead, Cody, or Connie, or anybody.
Yeah, so I want to address one other question. I am seeing ongoing questions about unemployment insurance, and just generally, C.A.R. has the walkthrough for it. Unfortunately, we can't get into things that are more specific than that, as a lot of those analysis, the analysis there is fact and circumstance based, and so it's not going to be helpful. It wouldn't be necessarily beneficial to make general assertions about that. If you have specific questions, you're more than welcome to reach out and talk to us after the fact, and we can try to help you through your specific circumstances.
Yeah.
John, we have a question regarding HIV disclosures. I saw that one up a bit ago, but I think it's a good thing to draw an analogy between that and disclosing COVID. Now, I think for starters, it's distinguishable because HIV is specifically not, it's laid out as something you don't have to disclose in California law. But do you want to draw an analogy and address why that's different? I know we addressed that yesterday as well.
Yeah. First of all, it is different. It's completely different. There are specific statutes that we have for those kinds of issues that we don't have here. Second of all, that issue was as much, it was a severe, and still is a severe health issue, but it was also very much of a political issue in terms of creating discriminatory practices. And so the rule is you while you can disclose someone died in the property within the last 3 years, you're not to disclose even that the property that they died of HIV. This is different. And so there is no, I don't think there's any semblance of a similarity between HIV and this. This is, again, we have very specific forms that say you will disclose what you know. And maybe if, let's say, for example, I've been tested because I'm old and I have asthma. So I was able to get a test that said I'm clean. And so I could disclose that to my absolute knowledge, at least for now, I don't have it if I needed to go visit a property. But if you haven't been tested, and then the question is, do you have any of the symptoms? Maybe you do, maybe you don't. Those are the issues that really, to me, it's a no-brainer. You know, first of all, why are you out? You're supposed to be quarantined. Why are you visiting other homes, visiting people if you're clearly not over the virus? And then if you've had it and you're no longer suffering from it, then of course there's always those residual issues that the medical people are still trying to figure out. So I think that's just something you should do. But I don't think it's really that similar to HIV. But apparently it's coming up because the second time in 2 days we've been asked the question.
And I see another question here kind of along the same lines. And I'll just ask you to expand on it maybe. It's more so referring to hepatitis and other things which you don't have to disclose. And I think that's interesting in that I'll kind of change the question a little bit. It's distinguishable because it's not something like a common cold. It's something that you can, I mean, it's life-threatening. It's very important. It's a worldwide pandemic. And I think it just needs to be disclosed, quite frankly. But these individuals, I've seen a few questions now about how to market that or how to disclose that a seller has that. And John, I'm interested to hear your opinions on this as well. But I would say in advance, it's the seller's information, the seller's property. really work it out with your seller to see how they want to address it?
Well, first of all, this question has come up a lot.
Mm-hmm.
If the seller actively, or someone in the residence, such as a child or maybe a parent who's living with the seller, or somebody has it or has a bunch of symptoms that would lead someone to reasonably believe it could be present, I believe it's a material fact. First of all, why are you letting people into the house if you are actively sick? Second of all, whether you've had it or not, there are protocols to follow. You make sure that the seller has opened everything up. You make sure that everything's been disinfected both before and after the visit, and then the seller is not in the property while the property is being reviewed. In all scenarios, it's been advised that the seller remove themselves from the property during the necessary review of the property. Keeping in mind what Cody said is you default to virtual, but if you have to go, then I think you have to make that disclosure. In fact, if you look at paragraph 7C, it specifically says you, the seller, or the party signing the declaration, will inform broker if after the date the document is signed there is a change in your health condition or knowledge that potentially puts you or others at risk or invalidates the representations you made. Again, this isn't just a snapshot in time. This is ongoing. I feel great today. Gene, you look great. Connie, you always look great. It's conceivable we don't have this illness, but we could get it. And at that point, the declaration we made today would no longer be valid. And so, again, what are we trying to accomplish here at the end of the day? We're trying to flatten out and then reduce these so-called curves so that we can, as quickly as possible, get back. This isn't about should I disclose or can I keep it secret? Think about the bigger picture. And frankly, I guess my attitude is, and you've heard me say this before, if you're not sure, disclose it. Because you're not going to get sued for disclosing information, but you could get sued for not disclosing it. One thing we haven't talked about, Cody, is a tort that we haven't really spent a lot of time thinking about, which is the infliction of emotional distress. Even if there's not an actual physical injury, the fact is that if I buy a house, move in, and find out that people had the virus, I'm going to be stressed. And so we might even see a claim or two about that. Any other questions?
Yeah, we have a lot. I'm trying to weed through them. I think a good one that hasn't been addressed yet is essentially what should a landlord or property manager do if the tenant didn't meet the time frame for letting them know that they were unable to pay the rent? So there's a 7-day time frame. What's your recommendation on that in the event that tenant comes in a couple weeks late and says, I can't pay it because I was laid off, or some other COVID-related reason?
Well, I know this is not what the property managers are going to want to hear. But the reality is while it's certainly there are rules that went into effect, Gene pointed out, the law that is being proposed. What that tells me, among other things, is that we're going to see some crazy stuff from the legislature. We've already seen, frankly, that there's not really a lot of analysis being done of the financial impacts all of these rules, particularly in California, are going to have on landlords. So my best advice, regardless of how you find out, if the tenant is not going to pay, try to work it out with them. If not, then you're going to need to make some financial, you're going to have to do a financial analysis of, okay, how's this going to impact me? Because realistically, you have no remedy right now. When we were in law school, Cody and I had a full year class called remedies, right? You go to the doctor, I know I'm sick, tell me how to fix it. Or you don't have a fix it right now. There is no way to get a tenant who is breaching the lease, including non-payment of rent, out. And I suspect that most of the burden is going to fall on the landlord. But if there's no qualification, the tenant could have paid, didn't lose their job, has the money, just refuses to pay, the reality is there's not anything you're going to be able to do about it, probably till at least July, maybe August, even into September. In Riverside, what they're indicating is that they're talking about opening up, I think it was July 15th, something like that. But they're going to take criminal cases first, because under the Constitution, criminal cases have to be done in a speedy manner. Then they'll probably take evictions, right? Probably evictions will be the first civil matters that they take, I suspect, and they'll do them based on first in, first out. And I've actually seen some opinions that it could take until well into next year before they actually clear the docket of all these cases.
Yeah, and just for point of reference, I saw recently that they were considering moving back the opening for some civil matters in Riverside to June 1st. So
June 1st.
It could be
That's
beneficial
great.
as it appears they're trying to move it forward. We just don't know what that's going to look like for tenants yet, or unlawful detainers.
But again, a lot of this goes to the underlying homelessness issue. They don't want to create homelessness during a pandemic. And so rather than trying to be specific and more analytical about this, they've just sort of thrown out a very large net and said, everybody's fits underneath this tent. And so just be aware that you're going to have to work with people. Take a look at those two forms that we referenced before. Take a look at the form that the notice that you should give a tenant, should have done that already, frankly. And then take a look at the form for working out the relationship, because there's a lot of choices that you have in there as you work it through.
If I could jump in here for a minute as well, there have been several questions about testing availability and so forth. There is testing available. You can either go to the rivcoph.org website. That gives you, there's graphic information on there as to number of new cases, number of total cases, number of deaths, and all kinds of information. There's also a number of links to other sites, including where you can get tested. There's also an 800 number on there because there is a mobile testing site in Lake Elsinore, and you can't make an appointment at that by clicking on the website. You have to call the 800 number. They have been, depending on the day you're trying to get in, there have been days when they're swamped. There have been days when they stand there most of the day without anybody coming through. So if you don't get through on the first opportunity, try again. But if you want to go to the Lake Elsinore site, you have to use the 800 number to call. There are now 5 testing labs across the county, so they're opening that up. They are now up to, and again, I was just on a call with Chuck Washington, our county supervisor, before I came on here, and they are now up to about 3,000 tests a day, which is better than they were doing for a long time. They've done about 45,000 tests so far countywide, but compared to a population of 2.5 million, that's really nothing to brag about, and they understand that. The only tests that are available right now to the general public are the nasal swab tests that show if you're currently infected. Now, there is a way that you can go through your primary care physician, and you may be able to get a hold of or be tested by one of the antibody testing facilities. And again, that will tell you if you have had it or if you have the antibody for it, but only for like the last 45 days. So as we see information coming out that this may have been around in the state of California, the first death logged in on February 6th, indicating that it actually was in the state prior to that, sometime back in January. And I know every time I post this, somebody goes, well, I was really sick back in December.
Mm-hmm.
You know, there is, we probably have established some sort of herd immunity in this state already, but there's not a way to test it right now because the antibody tests only go back 45 days. So if in fact you had it in February or January or December, there's no test available to tell you that right now. The difficulty is, and we're working with, you know, the cities, certainly the county, we would love to get things opened back up as quickly as possible because obviously all of our residents are hurting. Our businesses, particularly a lot of our small locally owned businesses, are really hurting. You know, you think you haven't been able to get unemployment insurance, you know, try having a business that's closed down through no fault of your own, and your landlord is yelling at you, and you can't get insurance, either the payroll protection or another form of insurance, because the federal government ran out of money. So I mean, there's difficulties back there, and that's why we're trying to encourage folks to be as patient as possible. We know people are running out of patience, and they're doing what they can. Just this past week, they've opened up some access to parks and trails and some limited activities. That will continue. The difficulty in a state like California is that the governor makes a one-size-fits-all rule, and that has to be predicated on worst case, which worst case right now, the county of Los Angeles accounts for about half the fatalities in the entire state. There are 42 states, mostly in the northern part of the state, that have either just a handful of cases, or in some cases, 21 cases have had no deaths at all. And yet they're under the same degree of lockdown and business closure that the county of Los Angeles is. So it's difficult to make a one-size-fits-all in the state of California. And we're trying to encourage counties, and you may have seen yesterday that the Orange County Board of Supervisors voted to open up the county. Well, it's a nice headline, but the reality is they're not opening up the county. If you read the article, it says we're opening up the county to the extent that the state allows us to, which is what everybody's doing right now.
Mm-hmm.
So, you know, we're trying to get Riverside County, but again, you can only do as a locality, as a municipality, as a city government, you can enact rules that are more stringent than what the county or the state does, but you can't enact rules that are looser than what the county or the state allows. So your hands get tied all the way up the ladder. And like I say, when you've got a state of California that has to make worst case regulations governing what's happening in Los Angeles County, sometimes it doesn't necessarily make a lot of sense for those of us out in the hinterlands where our numbers might not seem to add up to, you know, to what we perceive as going on in the marketplace. So again, we just urge your patience. You know, wear a mask when you're out in public, practice social distancing. I mean, we have flattened the curve, and the initial, you know, the initial thing to flatten the curve had more to do with not overwhelming our medical facilities. That was what flatten the curve was for. That has been accomplished. In fact, our medical facilities are so underutilized right now that they're laying off staff. They're laying off people because the bed count is way down. People aren't coming into the emergency rooms. People aren't going to their doctors, even for things like heart attacks and strokes, and cancer treatment is way off. I mean, this is, you know, this is serious across the board. So we're working with the county, we're working with the state to try to address some of these issues. But if you saw the governor's address yesterday, I think, day before yesterday on Monday, he came out with a four-stage plan to reopen the state. And, you know, we're still in stage 1. Stage 2 is weeks away. Stage 3 is months away. And opening up concert venues and that sort of thing that require larger gatherings, you know, when and if that will happen is way, way down the road. So it's difficult, but if you're trying to get an appointment, keep trying at that, because again, the county of Riverside has opened up their testing facilities. For the first month, it was really just, you know, people who had symptoms. Now they've opened that up to everybody. And obviously, the more testing that gets done, the happier everybody is, because if you only have, you know, a few tests, particularly when you were only testing people who were symptomatic, it looked like a very high percentage of people that were tested actually had the virus, and a higher percentage of those people were dying. Well, when you only test people that are, you know, that are already got one foot in the grave, essentially, you're going to get a higher percentage of positives. As you open up that testing to the general public, if you increase your testing amount by 10 times, and yet the number of deaths does not increase, you've actually reduced your percentage of mortality by that same factor of 10. So yeah, go out and get tested. We encourage that, and hang on there, because it's, you know, it is time consuming. It's just like the things, you know, the other things you're applying for, the pandemic unemployment insurance and so forth. The state's websites are being overwhelmed. They just opened yesterday, the PUA for independent contractors, realtors, and sole proprietors. And there are millions of those folks in the state of California who are all applying at the same time yesterday. So, you know, hang in there and keep trying.
All right, any other questions? Thanks, Gino, that was great.
Yeah, and there's a question in here, I saw it a bit ago, and it's regarding late fees. I know we had discussed that, and we've talked about that in great length, both inside the office and just between ourselves. Maybe would you like to take a stab at that? Would you like me to address it, John?
Yeah, you did a great job with our conversation. Go ahead and hit on it.
Yeah, so late fees, generally I'll say this. Our office does not practice putting them on a notice, and we try to generally refer to them as additional rent. When you go to an unlawful detainer, if that even, whenever that opens up, judges are hit or miss on that. I've seen judges who will take it and they'll give it on a default, and I've seen other ones who say it's an unenforceable liquidated damage provision. So practically speaking, it's a toss-up as to whether the court's actually going to grant it in an unlawful detainer. If you're trying to work through something with your tenant, it probably is not just practically advisable to start leading in with late fees. That might not create a amicable or friendly relationship. I've seen that as well. And then I guess generally there are very specific things that you need to be careful for when assessing late fees. For example, your county ordinances can prohibit it. I know, for example, LA County has a very detailed repayment plan and prohibits late fees. That's echoed through numerous counties. And off the top of my head, I just don't recall what Riverside's is. Similarly, if you're using some type of forbearance, then the CARES Act prohibits late fees in certain circumstances as well. So it really is a little, it's a little gray right now, I would say. Well, not gray, it's just there's a lot of factors. And so you need to be careful about how you're going about it. And if you have a particular circumstance which is concerning, reach out and ask us.
And it seems to me that going back to Gino's report on what the legislature's up to, if the legislature perceives that tenants are having a hard time repaying rent and late fees become common, I suspect we'll see a statute statewide that goes far beyond what is necessary to solve a problem. So how do I say this and not sound cynical? You're going to lose money. We're all going to lose money. All of us are going to get hit. You know, some of us own, I own, some of you know, I own the Stampede in Temecula, and we're closed. We still have people that are employed. We still have rent to pay. We're all going to lose money, some more than others. Some people have worked a lifetime to build a business that they live on the income from, and those businesses will never be able to open up again because they simply can't survive what's going on, and they are not getting any help, at least as of now. So just be reasonable. If your tenant truly does have a problem, can't pay the rent, is laid off, is had their hours cut back, is having an issue at the family level because of something related to all this, work with them. Don't be unreasonable, because I suspect that Cody's right, that what we're going to see are judges who are going to be inclined to wonder why you were playing Scrooge at a time when everybody was trying to work through a very difficult, never seen before problem.
And if I can,
and we're seeing it in all sorts of different ways. So just be very careful. Any other questions? Anything?
If I can add to that briefly, John, there was an interesting opinion that came out recently that the Bar Association posted, where a judge went to great lengths to ask a counsel why he was essentially playing Scrooge during these times, and laid out, consider religion, decency, just generally being a good person, karma, whatever you can consider and rethink your options, was essentially what he was telling this attorney. I feel like that's going to be coming. It's already becoming common, and that's
Right.
really going to become common in the UD section as well.
And Cody just hit on something, Gene, I don't know if you agree, but now's the time to really, excuse me, to really think through what's reasonable under the circumstances. Some of it's going to be general, much of it's going to be case by case. We're going to, one tenant may be a complete, Cody and I, remember, we live on the dark side of the force, so we've been seeing some horrific examples of some tenants that are grossly taking advantage of the situation, not allowing their landlords in even to fix problems, not paying their rent even though they could, potential threat of property owned by the landlord. So we're seeing all sorts of stuff. But by and large, most people want to do the right thing. And whether they're paying the rent because they can't, again, those landlords that have those tenants, I understand that you have your own problems. You have mortgages, you have insurance to pay, you have taxes to pay on your property. I understand all that. But that's why it's critical. One of the reasons realtors are hired is for their negotiating skills. And this is a time to use those skills to their fullest, I think. So, or not, and then make sure your lawyer's on good retainer because you're going to probably need them down the line. Because I think we're going to start seeing some of them. We've already seen lawsuits, big ones like Missouri suing China. We've seen lawsuits where people have been injured because of Walmart and they've sued Walmart. We're going to start seeing the day-to-day kind of lawsuits. And I don't know how they're going to flow, but the better you are at showing good faith, acting reasonably, adhering to the code of ethics, documenting your files properly, all those things, I think you're going to be far ahead of the game when this is over, whenever that is.
Yeah. Let's see. There's a few other ones coming in. One general one, which I know we're getting close to our time here, so it might be a good way to transition a little bit, is what kind of effects do you see this having on the just real estate offices going forward, John, in terms of maintaining a physical office or kind of the staff situation there?
Well, and I think Connie's probably more on top of this than I am. But it's my view that we're never going to see what we saw. We're never going to be back to where we were before. I mean, we may, we're going to see lots of change. I think I'm already talking to people like Connie, about, this idea. Today we had 300 people, that's great. You couldn't have 300 people in normal times because the room doesn't hold 300 people. So we're going to start seeing those kinds of changes. We're still going to have a shortage of housing, and we're still going to have more buyers than we have inventory for. We're still not building enough. I think my biggest concern, frankly, and this is my personal comment, this is not Connie, the board of directors, Gene, my personal comment is this is not the time to punish business. This is the time to try and figure out how to help business, including real estate developers, get more because again, there's so many factors that will go into the recovery. Obviously, I believe inventory will be very good. I believe that people that want to buy will still want to buy. It's going to be the jobs. It's going to be those people. How quickly can we go back to, or at least come close to, the unemployment rates that were driving a lot of what Gene was talking about before? You were seeing historic increases in the marketplace and historic kinds of good stuff if you're into a good economy, if you think that's a good thing. And how quickly can we get back to that? How is the impact on the November elections? What are we going to see there? Who gets elected? How they will approach this? Is it basically going to be taxation, or is it going to be getting the economy back up by getting jobs created? A lot of factors. I think we'll recover. I think that the economy is too strong. But again, the longer we stay in this, I think the longer. Gene talked about a V versus a U. My belief is that the longer we stay in this, the more like a flat U it's going to get than a big V. Yeah. I think had this ended quickly, which of course it never could have done, then I think we would have come back to a much quicker recovery. I think this is going to be a little more difficult because we don't know yet how many small businesses are not going to come back. We don't know how the airlines are going to recover. My wife was supposed to go to an all-week conference next week in Dallas. Now it's going to be done virtually. Well, if that becomes the norm, how's that going to affect hotels long-term? How's that going to affect conference centers? C.A.R. is having a series of meetings this week, right? Maybe they suddenly go, you know what, do we really need to have these 3,000 person business meetings every 4 months? So there's a lot that's going to change, and all that will affect housing, I believe. And I just think it's going to be a wait and see, but I think we'll recover pretty well.
The impact, and I think we were in a webinar with Joel, C.A.R. the other day. Joel Singer, our state CEO, is anticipating about a 6 to 8% drop off in the number of realtors this year. However, that will be at least partially offset because, as has happened in the past, when there are other people out there who are unemployed, they look to real estate. Real estate is one of those areas
right.
that
that's a great point.
And so any anticipated reduction may be offset in whole or in part by new people coming into the industry. And again, folks are looking at the state and at the national level to real estate as being one of the leaders out of this current economic situation. Because again, as John has mentioned, I mentioned, we were solid going into it. And the economy of this country was on some of its strongest footing ever in terms of unemployment and job growth and the stock market. I mean, you name it, it would be hard to find a period in time where our economy has been any stronger. And housing was the same way. We've been not stellar, but we've been strong for the last probably 10, 11 years. We've had some very good years in there and a couple not so. But this year was shaping up to be a great year. And once we come out of this and the economy gets back up, even on a limited basis, there's going to be pent-up demand. There are people who have wanted to purchase a home. Interest rates are going to remain at record or near record lows for at least the remainder of this year. So there will, our market will continue to be very strong down there. And I know our cities, we've put processes in place to take maps and development applications and so forth and continue to work on those because, again, you can't bring everything to a screeching halt. And we need to come out of this. We need to have housing developments that are ready to go. We need to have, entitlements that have been granted. We need to have plans that have been approved. And all of that stuff is continuing to work at the local and county level, certainly. So, obviously there are some concerns, but I think overall the indication is that housing should come out of this on a pretty good footing.
I think that's correct. My biggest concern, and I know this is going to sound political and it's not really meant to be, but when I see bills like 828, I wonder, is this legislature going to be a help or a hindrance to that development? I know that, as you know, Gino, because you and I have talked about it, I'm in escrow on a property myself right now, and I didn't cancel it. I just put a pause on it, right? And as soon as this thing is over, and my wife has told me that I want to go full forward, on it, and we'll go forward. That's what most people are going to do. There, if they can come back to normal on their income, then they'll go back to normal on what they're looking to do in terms of housing and moving and selling and all that. I just worry about what the legislature is going to do to hinder all that, whether it's hindering employers. I saw a bill yesterday, Cody's probably more familiar than I am, that would expand workers' compensation claims and allow employees to make claims in a much more liberal fashion than they are now. Well, that's not going to be helpful, particularly to businesses that are already suffering, from what's going on. So we'll see. I think, though, that, in closing, because I know we're out of time, I just think now's a great time to, number one, something Cody and I have been doing is reconnect with people. How can I serve you? I think a lot of the leadership that organized real estate is going to take is in the service to the public, because the public is looking to organize real estate, realtors specifically, to guide them through this process. And so the more you can reconnect, the more you can think through your strategies on a go-forward basis. You know, how can the association help you? How can you think through the strategy? What's it going to look like? You know, there's a lot of efficiencies that are being built in now that we never used before because we were so into face-to-face meetings. And, you know, Cody and I did a thing in Long Beach. Well, 2 months ago, I would have driven to Long Beach, right? 2 hours each way. Now, I got up at, you know, not got up, but I went online 10 minutes before the meeting. I got up a few minutes before that, but got online 10 minutes before the meeting to make sure everything was good, like what Daniel did for us this morning. And boom, there we are, right? So there's those kinds of efficiencies. There's going to be combinations. I'm sure Connie's going to look at education in a different way, right? Because all of a sudden you can make it convenient to that person, and we can do a lot of things better and differently by using this medium. We'll probably still have live classes. I know one of my boards is installing cameras in their auditorium.
Yeah.
Why? So they can do mixtures of both, where people can make that choice. So I think those things are going to be helpful. And last comment, Gino, is I really hate being called part of a herd.
The only thing worse, and here's the tricky part of that. Governor keeps pushing it, and he's going to extend the timeline until one of two things happens. Either we get a vaccine in place, which is probably 12 to 15 months down the road, or we establish herd immunity. And it's very difficult to establish herd immunity if you can't go out and be part of the herd.
Right.
So those things are very difficult. The only thing I hate worse than being called part of the herd, John, is to be deemed as a non-essential person by a legislature that is by and large less essential than most anybody else.
Is getting paid full benefits, full salary during this pandemic.
Oh, absolutely.
Yeah. I know.
Absolutely.
I know. Well, hopefully Nancy will invite us all over for an ice cream social before this is all said and done. And having said that, I think, Connie, I really can't thank you enough for putting this together for your members and giving the three of us a chance to, you know, tell everybody what we think is going on. And, you know, just we're all struggling right now. It's not fun to not be able to see my peeps, but we'll get through this. America's pretty strong. We've always seemed to be able to recover. It's time for some faith. It's time for some hope, and it's time for some charity. So with that, unless there's other comments, as far as unanswered questions, Cody, Daniel are going to work together to try to gather them all up. We can take a look at the questions that weren't answered, see if we can figure out how to get Connie some additional information if there were lots of questions that couldn't be answered. Take a look at the Code of Ethics article. It does affect liability. And then the next article is going to be a little more specific about some things you could and could not do, just so you have sort of a checklist that you could give your people. Anything else? Cody, Gino, Connie?
No.
Comments,
Good.
questions?
That's it. Thank you, guys.
Thanking everybody.
Thank
Nice
you.
Thank you
seeing
for coming
all.
today. Peace and love.
Peace and love. Bye.